Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. 1.5 minutes late. I apologize, folks. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you very much. And yes, I do plan to talk to our creative folks about all the O-face thumbnails. I'm getting rather weary of those myself. So we'll get that straightened out. They have other pictures of me to choose from, for sure. A couple things. One, there was no show yesterday. That's because I was in court. I had to attend what was called, what we call here in Colorado, a Shrek hearing, just like the cartoon character, believe it or not. And it's a hearing in which a proposed expert witness is subject to questioning by the party, presenting him to the court, cross-examination by opposing counsel, and then the judge makes a decision on whether or not they'll be permitted to testify at trial. And this is all for an upcoming murder trial here in Colorado. It's a chokehold trial, not unlike the one in New York City on the subway. And yesterday I had to appear in a Shrek hearing to be qualified as an expert by the trial judge for purposes of the actual murder trial, which is going to happen this week. Thursday or Friday will be the murder trial. And of course, you'll be shocked to learn that this judge found me eminently qualified as an expert on use of force law. You might ask, how many times will Andrew have to do this? The answer is every time. You have to do this every time you're proposed to be an expert witness in a trial. So I was qualified by the judge. I will be providing expert testimony on use of force law at the murder trial, which means whichever day of this week that trial takes place, either Thursday or Friday, there also won't be a live show, folks. Now, there is no streaming of this trial. There's no way to watch it. There's no way to watch my performance live unless you wanted to be there, I guess. It's at the El Paso County Courthouse here in Colorado. Division 17. The trial is the Luke Herndon murder trial. Really, it's a second-degree murder trial, so really it's a heat of passion manslaughter trial, but Colorado refers to it as second-degree murder, and then you mitigate the murder down to manslaughter based on the heat of passion argument. But what I will try to do, and I can't record it myself, that's not permitted, but what I will try to do is obtain a transcript of my testimony, and we'll do some show content around that transcript. If that's possible. So I apologize. We're going to be a little short this week on new content, but that's why I got involved with a client matter. And that always, I'm sorry to say, has to take its priority, because people shouldn't go to jail for much of the rest of their lives unless they've had due process of law. And when I can, especially for you platinum members, really only for you platinum members, I will be there for you, guaranteed. So in most states, this would be called something like a Daubert hearing or Fry hearing. There's slightly different standards, but here they call it a Shrek hearing. So yeah, I mean, it'll go fine for me. I'm not worried about it. The worst case for me is me not going to prison, right? It's the defendant who has stuff to worry about. So, but we'll do the best. We'll help. I'll help the jury make an informed decision. At least we'll know that when the jury is the ultimate decider on the verdict. I don't control that. The judge doesn't control that. The prosecution doesn't. The defense. But I see too many cases where the jury arrives at a verdict, and it's apparent to me that they didn't even know what the right question was. And if you don't know what the right question is, you certainly can't hope to arrive at the right answer. So at the very least, I can ensure that this defendant can be confident that the jury at least got the right question. And then they have to interpret the evidence presented to them and come up with the answer. But at least they'll have the right question. Another upcoming change I wanted to mention, and that is recently we've, in the last month or so, we've sharply curtailed how much of our content is going out open access on YouTube, on Rumble, on Twitter. In fact, as long as we're doing this, let me take a quick look and make sure that we are streaming where we need to be streaming. Let's see. Okay, there we go. All right, that's all good. So right now, only about 40% of our content, our weekly content, our live streams is going out open access. So to our law self-defense members, of course, everything goes to our members on their member dashboard. But only about 40% of the content, a couple of shows a week, is going open access on YouTube, Twitter, and Rumble. We're going to continue that pattern moving forward, but we're going to add a layer, and that is only the most recent, probably 20 shows will remain accessible on YouTube, Rumble, and Twitter. The others will be made private or deleted or however that's done. I don't know. So that there'll be a rolling window of 20 shows that's open access on YouTube, Rumble, and Twitter. But if you want continual access to the thousands of videos in our archives, those will only be available to Law of Self-Defense members. And if you're not a Law of Self-Defense member, I really have to ask you, why not? Because it's dirt cheap. In fact, you can try it out for only a mere 99 cents for 2 weeks. Try out unlimited. You get access to everything on our blog, all our videos, all our member-only podcasts, all our written blog posts for a 2-week period for 99 cents. And if you cancel in that 2-week period, we'll give you a 200% money-back guarantee. So it's a negative risk opportunity. And if you decide to stay a member, and virtually everybody does, it's only 30 cents a day, folks, about 30 cents a day. It's less than $10 a month to be a Law of Self-Defense member. So it's crazy inexpensive on an individual basis to be a member and have ongoing continual access to our content, including the 60% of content we put out every week that is members only from the very start. And for those of you who really want the smart play, you might consider this option, which is our Platinum member offer that we currently have out for maybe a few more days. Platinum membership is the only way. That's our highest level of membership. Those are the only people who have access to me as a legal consultant on their use of force case, if they're ever involved, to use force in defense of themselves, their family, their property. If you're not a Platinum member, I can't help you. And the Platinum members get that legal consult, which would otherwise be a minimum of $10,000 retainer and goes up from there. The Platinum members get that legal consult for free. And you get all the other benefits of being a member, unlimited access to all our content. And you get the Platinum member Q&A form where you can, that's on the our webpage, only for Platinum members, where you can submit questions directly to me. And you can get all that, folks, for 82 cents a day. And guess what? We'll also throw in every course, class, book that we have available. That's $3,000 worth of educational content and use of force law, our full day course, our 3 state-specific courses of your preference, our defense of property course, defense against riot, looting, and arson course, how to choose self-defense insurance course, and a lot more. $3,000 worth of content, $3,000 worth of Platinum coverage for 5 years for you and your wife, your spouse, for 82 cents a day. 82 cents a day. So something to think about, folks. You might want to take advantage. You can learn more about that at lawofselfdefense.com/82 cents. But at the very least, you should definitely try out our trial membership. That's only 99 cents for 2 weeks, folks. And you can try that out at lawofselfdefense.com/trial. All right. So with that housekeeping out of the way, let's jump into the meat of today's show. Here we go. All right, well, that image was supposed to end up looking like this. Our normal little silly animation didn't work, but we're here to talk about the Trayvon Martin case, George Zimmerman case. So this year is the 10th year anniversary of Trayvon Martin's poor victim selection decision in targeting for grave bodily injury an armed man, George Zimmerman. Simply an innocent member of his community, volunteering for Neighborhood Watch in a community that had been ravaged by burglaries and home invasions, stolen property in recent months. That's why they created a neighborhood watch program. Zimmerman volunteered. He was accepted by the police department, which oversaw these programs. He was trained by them. He followed his training to the letter. He did everything the police told him to do. And he got attacked by Trayvon Martin. And because this is the 10th year anniversary, it's kind of back in the news. Now, what happened? What happened when he was attacked by Trayvon Martin? Well, George Zimmerman was carrying a Kel-Tec 9mm pistol. And while he was getting his head beat into the sidewalk, he was on his back, mounted by Trayvon Martin, eyewitness testimony at trial, being beaten ground and pound. His jacket fell over. The gun became visible. Trayvon Martin saw the gun, threatened to kill George Zimmerman with it. So George drew the gun himself, fired a single round, struck Trayvon Martin in the chest, penetrated his heart, and killed him. And George Zimmerman would ultimately be brought to trial on second-degree malice murder charges in Florida on an utterly fraudulent information, which is the equivalent of a grand jury indictment. Utterly fraudulent, made unbelievably outrageous claims that were never repeated at trial. So this falsely sworn document is how they dragged George Zimmerman into a trial where the state had the burden of disproving self-defense beyond a reasonable doubt, and there was zero evidence inconsistent with self-defense in that trial. And appropriately so, George Zimmerman got acquitted. Of course, if you watch the news media coverage of the trial, you only heard the propaganda version of events. And the propaganda version was that George Zimmerman was a terrible racist who shot and killed a black child, for the crime of having Skittles and iced tea, of being black and wearing a hoodie, of being black in George Zimmerman's neighborhood. It was racism. That's why George Zimmerman killed Trayvon Martin. And of course, if that's what you were told and that's what you believed, you would consider the acquittal of George Zimmerman to be an outrageous injustice. It's when you know the truth that you realize what a vicious little thug Trayvon Martin was and how lucky George Zimmerman was to survive that conflict and be acquitted at trial of all charges. And by the way, George Zimmerman was acquitted and his life was utterly destroyed. He lost everything: his job, his wife, his life as he knew it. I came to know George after the trial, and he was a basket case for a long time. I mean, he was literally suffering PTSD because the state of Florida, George Zimmerman merely defended his life, and the state of Florida tried to put him in prison for the rest of his life. George Zimmerman, who considered being a police officer, a prosecutor himself, who was studying criminal justice, who volunteered for his neighborhood watch program. He was a good guy. His neighbors loved him. Neighbors of all races testified at trial. They thought he was great. He was the helpful guy in the community. And the state of Florida tried to railroad him into a life sentence when there was zero evidence inconsistent with self-defense. But because of the propaganda, this was an opportunity for a lot of value to be created in terms of money for people like Benjamin Crump, attorney Benjamin Crump, who was a racial and racist firebrand in these kinds of cases, part of what I call the racial grievance industrial complex. But it's not just money that can be made, and Crump made plenty. He got a quick settlement from the apartment community in which Zimmerman was living and in which he was a neighborhood watch volunteer. They settled quick, so that was a quick dose of money for Ben Crump. But also there's value to be created in terms of political capital, power. So the original prosecutor in this case, the prosecutor in the jurisdiction where this event took place, he thoroughly investigated for weeks this case. They had a series of team meetings between the prosecutor and the police investigators. They looked at all the evidence. And they couldn't find any evidence inconsistent with self-defense. And Zimmerman's narrative of self-defense was consistent, both internally consistent with itself every time he told it, and he told it frequently, generally without legal counsel present, which is not advisable. But it was also consistent with all the eyewitness testimony and all the physical evidence. This was self-defense. And that prosecutor refused to bring charges. But once Al Sharpton and Benjamin Crump got involved, once this became a politically energized case, the political pressure on the prosecutor to bring charges became so great that guess what he did? If you're thinking he broke down and brought charges against George Zimmerman, you're mistaken. He quit. He resigned. rather than unethically bring criminal charges against George Zimmerman. Now, what happened then? Well, the governor of Florida now had an opportunity. He could appoint essentially a special prosecutor. And he found one in a different jurisdiction in Florida, Angela Corey. These are elected prosecutorial positions. Angela Corey was in the Jacksonville area of Florida. And prosecutor Angela Corey had a big problem. She had a big problem with the Black demographic in her community that would be asked to vote for her, because prosecutor Angela Corey had brought charges against some Black people in that community that made her very unpopular with the Black demographic. And you may remember the case of Marissa Alexander, who supposedly, the propaganda in her case was she just fired a shot in the air when she was dealing with an abusive and violent husband. That's not what happened. She shot a bullet at her husband's head while he was holding their 2 children, missed his head by inches. The bullet hole was in the wall next to where his head was. For no good reason. She was under no attack by him. She actually left the scene of their fight, went to her car in the garage, got a gun, and came back to fire that shot. It wasn't a shot into the ceiling. Ironically enough, the bullet ultimately did hit the ceiling because it went through the wall on a rising trajectory into the other room and ultimately hit the ceiling in the other room. But that's not where she fired it. She fired it at this dude's head, and he's lucky he didn't get his brains blown out while he was holding his 2 children. His 2 children would testify in court that they thought they were going to die next. So Marissa Alexander was charged with 3 counts of aggravated assault with a deadly weapon and was looking at 60 years mandatory minimum in prison in Florida. But if you believe the propaganda that she's just a victim of domestic violence who was defending herself and merely fired a warning shot into the air, into the ceiling, it looked like Angela Corey was engaged in a miscarriage of justice. She wasn't in that case. She also brought charges against a young Black male, I believe he was 13 or 14 years old, of murder. Murder. How can you charge a 13 or 14-year-old with murder? Well, because he'd murdered somebody. That's why. But of course, if all you do is present a child and a murder charge, it looks unreasonable, especially if it's propagandized. Well, she had a problem. So Angela Corey was running for re-election in a jurisdiction with a large African-American demographic, and they were having marches in the street against her. She was going to lose that election. And then the local prosecutor in the Zimmerman case resigned, and a spot opened up. And she saw that she could regain her political capital by championing the prosecution of George Zimmerman, the racist murderer of Trayvon Martin. So she got herself assigned to that job, became essentially the special prosecutor in the George Zimmerman trial, and basically tried to railroad George Zimmerman into a life sentence on no evidence. Now, the marchers in the street by the African Americans in the community, they weren't against Angela Corey. She was at the head of those marches. She was marching beside Al Sharpton and Benjamin Crump. And guess what? Angela Corey won re-election when she was almost certain to lose it, because of the political capital she built off the wrongful prosecution of George Zimmerman. Now, of course, Zimmerman was acquitted. So people say, well, Angela Corey lost that trial. And I have to respond, well, it depends on what you mean by lost. If you mean, did she lose on the legal merits, the trial itself? Of course, Zimmerman was acquitted. But was that her real purpose in prosecuting Zimmerman? Or was her real purpose the acquisition of political capital to avoid electoral defeat? Because if that was her mission, and I think it was, well, then she won. And that's what happens when you have these politically motivated prosecutors. The whole situation becomes a win-win for them. There's always a chance, no matter how innocent somebody is, that they could get convicted at trial. Zimmerman could have been convicted. There's a 10% chance, at least. A roll of the dice could go the wrong way. Innocent people get convicted all the time. So maybe Angela Corey was thinking, hey, I'll take the roll of the dice. I got some chance he gets convicted. And then I can say, see, the jury agreed. I was right all along. But even if I lose a trial, I'll win re-election. So there's no way to really lose in this case. So that's kind of the political background around this. And people have never stopped building political capital off of George Zimmerman and his persecution, his wrongful prosecution in this case. They continue to do so today, and I expect we'll see a lot more of it this year, because we're right. This This month is the 10th anniversary of the acquittal. So people have been preparing articles and news reports, and we'll have memories of Trayvon Martin and his Skittles and iced tea and all this nonsense. And one of those items that popped up on my radar screen yesterday, which will be the focus of our show today, is a law review article out of Marquette University Law School. And it is a piece of hot trash. And only part of it is directly talking about the Zimmerman trial, but they use the Zimmerman trial, their misrepresentation, they're propagandizing, they're lying about the Zimmerman trial as a foundation for then saying, well, see, now that we've shown you all that stuff about the Zimmerman trial, which is all lies, it's a foundation of garbage, hot garbage. We can build on that foundation a vision of systemic racism through all the things. The trouble is their very foundation on which they built the rest of the article is trash. And that's what we'll be doing today, is debunking that. Just as an example of the, before I do that, I can't believe I forgot this till now, but I did at least prepare for it. Hey, how about a little remembrance today, June 6th, for these guys who on this day, 1944, stormed the beaches of Normandy at a great cost to themselves. Were they the finest generation? They were in this battle. They were in this war. Of course, they raised the next generation, which didn't turn out so well. So maybe a mixed bag. But on this day, they were champions. So thanks, fellas. We still appreciate it. All right. So as part of the propagandizing that went on, a big part of it was stuff like this. This was the image the world was presented of Trayvon Martin. Look at this cute kid. Look how nice he is. The Hollister t-shirt. He's about 13 years old in this picture. There's other pictures like this where he's in a aeronautics museum. He's going to become a space engineer. It's nice, huh? It's really good. Very, very pleasant looking young man. He looked nothing like that the day he attacked Trayvon Martin. The day he attacked Trayvon Martin, he was a large, tall, muscular, football playing, street fighting, drug using, gun carrying, apparently thieving thug. And of course, this is how George Zimmerman was portrayed. Look at those jowls, the prison orange. This cute little kid, Trayvon Martin, and that mean, big old man, George Zimmerman. This is also Trayvon Martin with his gold grill. These next few photos I'm going to show you are photos from Trayvon Martin's cell phone that the judge in this case, who is, in my view, heavily biased against the defense, Judge Deborah Nelson, wouldn't allow any of these photos into evidence. None of them. Showing the different character, the different side of Trayvon Martin. That might have informed the jury in their deliberations, might have shed some light on the likelihood that George Zimmerman's story of being innocently attacked had merit. Trayvon Martin with his grill. Trayvon Martin with his grill and your number one fingers. Not so much this kid anymore, right? Little different in this presentation. Trayvon Martin with a gun. Now, he died at 17, so he was younger than 17, or at least no older than 17, when this photo was taken on his phone. A gun, ammo, finger on the trigger. Trayvon Martin street fighting. Street fighting. By the way, there were also text messages on his phone to other people where he talks with them about his preferred street fighting technique, which is to get a quick blow into the person's face, knock him down, mount him, and then beat him on the ground from a mounted position, ground and pound MMA style. You know how he attacked George Zimmerman? Exactly the same way. The same modus operandi. Quick punch to the face, mounted him on the ground, beat his head into the sidewalk while he was mounted on the ground. This was not allowed into evidence. Those text messages were not allowed into evidence by Judge Deborah Nelson. Trayvon Martin smoking. Oh, maybe he's smoking cigarettes, right? Maybe he's just smoking cigarettes. Oh, I forgot to show you. Here's the street fighting photo. So these are organized street fights that Trayvon Martin was engaged in. He wanted to be good at this. His father, by the way, had been a long-time gang member, either the Bloods or Crips. I don't keep count. All the neck tattoos, the whole thing. He aspired to be more like his dad. Trayvon Martin smoking. Maybe just cigarettes, right? Could be just cigarettes. Who knows? I don't know why people would take pictures of themselves smoking a cigarette. But here's another photo from Trayvon Martin's phone. That's not tobacco, folks. That's the wacky tobacco. That's marijuana. Trayvon Martin, the year in which he was killed. Not this kid. This isn't the kid that George Zimmerman shot. This is the kid that George Zimmerman shot. Because this kid had knocked him in the face, knocked him to the ground, mounted him, was beating his head into a sidewalk. Eyewitness testimony affirmed this. The person in the hoodie, Trayvon Martin, was mounted atop the other party, swinging on him. Ground and pound, MMA style, the words of the eyewitness in the witness stand. Trayvon Martin, this is the convenience store where he bought the iced tea and Skittles that were in his possession when he later decided to attack an armed man. This clerk in the convenience store on the left, he testified at trial. He said he's about 5'10". Look how much taller Trayvon Martin is. This is not the person who attacked George Zimmerman, who George Zimmerman had to defend against with his life at stake. This is that person. Again, this photo was on Trayvon Martin's cell phone, not admitted to the jury. They never saw it. This image was shown to the jury. This is from, of course, a surveillance camera in the convenience store. And the people who lie about this trial for the racial grievance industrial complex hate this photo. They hate it. Now, they can't knock it on a factual level. There's no lie here. This is how tall Trayvon Martin was. So they say it was even racist to show it because it makes it look like he's robbing that convenience store. Nobody ever claimed he was robbing the convenience store. But they have to try to counter this image in some propagandistic manner, so that's what they do. And we'll see that. They do that in the law review article, this image here. All right, so let's get to the actual meat now of this article. By the way, folks, we announced this change previously, but moving forward, we're only taking questions and addressing comments that are in the Law Self-Defense member chat. So don't bother with the super chats or the Rumble rants. We're just not looking at those anymore. It became too cumbersome to be switching around. So before I jump into the article, let me see what kind of member stuff we have already. We do have a lot of new members. One question that's come up is we live stream on the member dashboard, and people are asking, well, where did the shows go after that? They go onto the member blog, folks, as replays. And they also go out as member-only podcast content. So after the show's live streamed on the dashboard, if you want to find it after that as a replay, you'd go to lawofselfdefense.com/blog. You'll need to be signed in as a member to access those. Tony asks, how much liberty does the judge have over the standard jury instructions? So this is unrelated to the Zimmerman case, but I'll address it. So in the old days, jury instructions were drafted brand new for every trial. Now, of course, lawyers had drafted jury instructions before, so they tended to use some variation of what they'd used before. So it wasn't really from scratch. But there were still variances in jury instructions from trial to trial, from murder trial to murder trial, even with very similar facts. And of course, the jury instructions are kind of the computer algorithm for the jury, right? It's how the jury is supposed to apply the facts to the law. So you'd end up with very similar cases getting very different outcomes, arguably because the jury instructions were a little different. The program was a little different. The algorithm was a little different. So the states all began to standardize their jury instructions. The state Supreme Court would approve a set of jury instructions that every trial judge was supposed to use. And if you didn't use them, or if you substantively changed the approved jury instructions, it was a great way for a trial court to get reversed. I'll zoom that out while I'm talking about this. So trial judges don't like to make substantive changes to jury instructions. Now, there is a balance here because there's always some adjustment made. For example, jury instructions will commonly have fill in the blanks for the defendant's name or the victim's name, or like if it has a weapons enhancement, there'll be a specified weapon, perhaps. So they're always customized a little bit for the specific facts of the case. But any substantive change that reflects how the law might be applied by the jury, trial judges hate to do that. Now, the prosecution and the defense will argue for those kinds of changes all the time because they each want a version of the jury instructions that's most favorable to their narrative of the case. But trial judges are very averse to substantive changes in jury instructions because it's probably the single best way for them to get reversed on appeal. Let's see. Jeffrey says, I listened to your panel discussion with the For Science Institute firm last year dealing with the taser case, the Kim Potter case. Yeah, that would have been a year or more ago, I guess. Very interesting hearing the different experts' views. Do you foresee participating in similar panels in the future? Yeah, I speak on other people's shows and stuff all the time. So I'm generally happy to do it. Tony asks, in the Zimmerman case, was disparity of force due to size ever raised? Well, it actually was an interesting problem. So I didn't know George Zimmerman at the time of the trial. I didn't know any of the lawyers involved. I didn't know the defense counsel in particular at the time of the trial. Since then, I have come to know George Zimmerman, and I've become particularly good friends with Don West, who was one of George Zimmerman's two counsel on the case. So I've had lots of conversations with Don about this trial after the verdict. And Don shared a very interesting observation, and that was before George Zimmerman was attacked by Trayvon Martin, he had been on a weight loss program. He had joined a local gym, and it was working. And he'd lost a ton of weight, and he was getting pretty slim. And he was in that slim condition when he was attacked by Trayvon Martin. Unfortunately, between the night of the attack and when the trial started, George Zimmerman, under all that stress, not knowing if he was going to spend the rest of his life in prison, all the press propaganda being characterized as a monstrous, racist murderer of a black child, well, he responded to that stress by eating a lot, and he gained a lot of weight. And so the person who showed up to trial, the George Zimmerman who showed up to trial, was a lot bigger than the George Zimmerman who'd been attacked by Trayvon Martin. So it kind of closed the door on the defense being able to make a disparity of size argument because the disparity of size wasn't apparent to the eyes of the jury. It was a problem for Don West. He was pretty unhappy, maybe too strong a word, but he certainly would have preferred that George Zimmerman had remained slim. All right, so with that out of the way, let's turn back. Let's go to this piece of hot garbage law review article. And by the way, I mean it this time. So, of course, I reviewed a law review article a couple of months ago now. Professor Marcus Funk out of the University of Colorado Law School. That was not hot garbage, and I made that clear when I reviewed it. I wasn't sympathetic to some of the perspectives he took on self-defense law. I have a different view on some of those. Believe it or not, some of you will know if you've been law self-defense members, after I did that critique of Professor Funk's law review article, he actually reached out to me and was not at all defensive or offended. We ended up having lunch. He ended up coming on my show, and we talked through an updated version of that law review article. In fact, he now cites me in his law review article, and which is very kind of him. And he's a great guy. But that's not what we're doing here. Funk's law review article, I had differences of opinion on how best to approach or describe or view or understand the law of self-defense. This thing we're going to look at right now is a piece of hot, steaming garbage, period. Period. Professor Brodin, Mark S. Brodin, professor, and Michael and Helen Lee, distinguished scholar, Boston College Law School. So this piece is published by Marquette, but Professor Brodin is at Boston College Law School. I'm glad I didn't go there, although we probably have propagandists like this at my old law school too these days, which is Hofstra School of Law. So the legacy of Trayvon Martin, Neighborhood Watch's Vigilantes, Race, and Our Law of Self-Defense. Now, I'm not going to read the whole thing. I think it's about the first 10 or so pages, each of which is half of it is footnotes. I'm just going to go through the first part here, which sets that foundation of the Zimmerman trial. Oh, you know what I love most about the President Barack Obama administrations, his 2 terms, was all the racial healing. So he's got a quote here from Barack. Reflecting back a decade later, what is enduring significance of the Trayvon Martin case, a black teenager whose life is violently cut short in a legal system that accepted his death without consequence. The poet Elizabeth Alexander speaks of the Trayvon generation, of black youth who have grown up in the haunting shadow of his killing and the anguished parents who cannot protect their children from such a fate. This might be a good time to remind everybody that according to the FBI Department of Justice crime statistics, 60%, roughly 60% of the violent crime committed in America is committed by the roughly 5% of the population that is young black men. And they're mostly committing that violence against other young black men. Who young black men in America need to fear is not George Zimmerman or anybody like that. They need to look in the mirror. Continuing, America's first black president spoke for them. Quote, when I think about this boy, I think about my own kids. If I had a son, he'd look like Trayvon. Would he? Would he, Barack? He'd look like Trayvon? He'd look like Trayvon? He'd look like Trayvon. He'd look like Trayvon. He'd look like Trayvon. Like Trayvon. Like Trayvon. He'd look like Trayvon. By the way, there were other images available from the scene that ultimately the jury would be shown, but which the media did not show the general population in any meaningful sense. For example, there was this photo taken at the crime scene immediately after the police officers who George Zimmerman called before he ever encountered Trayvon Martin, called to the scene. He called for the police before he ever encountered Trayvon Martin. This is what the police found when they found George Zimmerman. Look at that nose. Look at that blood. That's the blow that took George Zimmerman to the ground where Trayvon Martin mounted him to continue his vicious, life-threatening attack. Then George Zimmerman was brought to the police station. He was cleaned up. But even after he was cleaned up, still had images like this. These injuries on the back of George Zimmerman's head are the result of the sidewalk against which the back of his head was resting when Trayvon Martin was beating Zimmerman's head into the sidewalk. The media didn't show these images to the press. You think these injuries, you think this injury, you think it was caused by this kid? You think it might have been caused by this kid? By this kid? By this kid? All right, let's get into the heart of this. Before they even get into the Zimmerman propaganda, they get into some earlier propaganda. This is the Willie Horton propaganda from when Massachusetts Governor Michael Dukakis was running for president. He had a big lead over Bush at the time. This would be Daddy Bush, Poppy Bush. And Lee Atwater, a Republican strategist, devised a game plan to release the Willie Horton ad. Willie Horton was an African-American serving a life sentence for murder in a Massachusetts prison, and Massachusetts Governor Michael Dukakis let him out on a weekend furlough. He escaped, kidnapped the young couple, and brutally raped the woman and tortured her fiance. This is a lie, by the way. Lee Atwater may have made use of this image of Willie Horton, who was released on a weekend furlough by Dukakis and raped this woman and tortured the fiance. He did all those things. And he was released by Dukakis. But you know who released that picture first? It was the Democrat running against Dukakis. It was the Clinton campaign. Released it first. You won't hear that here. Hold on a second, folks. Sorry, somebody came into the office and I was not expecting them. So in the lore of the racial grievance industrial complex, it was those horrible Republicans who managed to steal the election away from Michael Dukakis by what? By showing the photo of someone who'd been released by Michael Dukakis on a weekend furlough and raped a woman and tortured her fiance. They call it, in 1989, the year after Dukakis was Willie Horton. What does that have to do with anything with self-defense law? Nothing, of course. But it's part of the racial grievance industrial complex lore, historical lore, a catechism, the things you just have to believe to be part of that tribe. Then they go on to another completely unrelated case. Charles Stewart in Boston. In 1989, Charles Stewart killed his wife, who was from a very wealthy and powerful family. I guess he had a mistress someplace. So Charles Stewart killed his wife and blamed it on a young black male in a hoodie. He was discovered. He fled from police. But meanwhile, the police were kind of ransacking Boston, looking for the suspect of this murder of this young woman. But Charles Stewart was found out. He climbed on top of the Tobin Bridge in Boston, one of the major bridges in Boston, and he jumped off the bridge to his death into the waters below. True enough, all this is true. Nothing to do with self-defense law or neighborhood watch or George Zimmerman. Nothing, any of it. Just part of the catechism of the racial grievance industrial complex. And Emmett Till, of course, you can't possibly have a conversation like this without going back to the 50s. Okay, so now let's move on to George Zimmerman. Quote, what George Zimmerman saw that rainy Florida night in 2012 was not a skinny 17-year-old high school student bringing snacks to join his father to watch the NBA All-Star game, but the dark figure in D.W. Griffith's wild, distorted imagination prowling in his neighborhood. Trayvon was, as Reverend William Barber put it, guilty of nothing more than walking while black in a gated community. Here's what really happened. The whole region, the whole country was going through a real estate crisis. And a lot of people in this apartment complex had bought apartments they couldn't keep anymore. So they abandoned them or they gave them back to the bank. And what was the bank going to do with all these properties? Nothing. So they offloaded them as quickly as possible, often to investors who were buying these abandoned apartments. And what were the investors doing with the abandoned apartments? They were turning them all into Section 8 housing, which is basically welfare housing. So in what had been a relatively middle-class upscale apartment complex, we're suddenly brought in a population that had much higher than the usual crime statistics for this neighborhood. And this apartment complex became overwhelmed with thefts of property. If you left your garage open, your lawnmower would be gone in an instant. With burglaries of the dwellings while people were off at work being productive. With home invasions while women and children were inside their own apartments cowering in closets. while the place was being ransacked. That's what was happening in this community. And so the community decided, you know what, we need to do something. And every time the cops were called, they got there too late. They got there after the suspects had fled. So the HOA of the community said, we need to do something. They had a meeting. They said, let's talk to the cops, the local police department, Sanford, Florida Police Department, about setting up a neighborhood watch. How would we do that? What's the best way to approach it? What's the best way to execute on a neighborhood watch program? So Sanford PD came in. Sanford PD had a woman on staff who was a liaison for precisely this purpose. She provided the training for Neighborhood Watch, explained how it was to be done. And one of the volunteers for that Neighborhood Watch program was the good guy in the neighborhood, George Zimmerman. He volunteered. And their training was basically, hey, if you see something suspicious, call us on this number, and we'll send cops out to investigate. Don't engage, don't interact, just observe and report. That was George Zimmerman's training. If you see something suspicious, call us. So what happened that dark night in 2012? Well, it was raining. It was dark. It was February. So it got dark early, even in Florida. And George Zimmerman had been running an errand. He'd run out to buy the food he would use to make the lunches he brought to work the next week. And he was coming back through his community in his car in the rain, and he observed a figure wearing a hoodie, apparently peering into the windows of apartments, much like might a burglar who was looking for an opportunity. By the way, guess what was found in the bushes near where George Zimmerman was attacked by Trayvon Martin? Burglary tools. We'll never know for sure if those are Trayvon Martin's burglary tools. We do know for sure that he was suspended from school because he had stolen property, jewelry, in a school locker. But burglary tools were found in the bushes near George Zimmerman and Trayvon Martin's fight. So was Trayvon Martin actually scoping out the apartments for an opportunity to burglarize them? The apartment complex that had been awash in burglaries and home invasions and property thefts for weeks and months? In any case, to George Zimmerman, who knew this history of the thefts and burglaries and home invasions in his neighborhood. That's why he was part of the Neighborhood Watch. He knew that history. He saw a suspicious character. He'd been trained. If you see someone suspicious, call us on this number. And so that's what George Zimmerman did. You know, I didn't think of it beforehand. Let me see. Okay, I do. I have it. I have it. Let me see if I can play for you the entirety of this. I got to hold on a second. I have it in different formats, and I need to make sure that I can open it up as I need to. Let me see. Let me see if I can pull this off on the fly. Okay, that didn't work. Let me try this. All right, I think this will work. So let's listen. Let's listen to the entirety of the 911 call between George Zimmerman and Trayvon Martin. So George Zimmerman sees interaction between George Zimmerman and the police, the dispatcher on the phone. It's about a 4-minute long call. I'm going to play you the entirety, the unedited, because the news media cut portions of this out to make George Zimmerman look bad. And I'll remind all of you that one of the lies about the George Zimmerman case was that George Zimmerman got out of his car after being told by the police not to get out of his car. So I want you to all listen for that supposed moment when the dispatcher says, hey, don't get out of your car. And then George Zimmerman gets out. Spoiler, that doesn't happen. All right, so George Zimmerman sees this character in a hoodie, shrouded, walking around in the rain, no apparent purpose, peering in people's windows, looks suspicious. So he does exactly what his neighborhood watch training told him to do. He calls the Sanford Police Department dispatch and has this conversation with them. By the way, you think someone who's about to commit a racist murder, first they call the police and say, hey, could you send some cops out here to take a look at this guy? He looks suspicious to me. Is that what a murderer does with malice, which is the crime George Zimmerman was charged with? Malice murder, hate murder. Okay, let's take a listen. Whoops, I lost my cursor. There it is. Okay.
Sanford Police Department, lines being recorded, Sean. Hey, we've had some break-ins in my neighborhood, and there's a real suspicious guy. It's Retrieve You Circle. The best address I can give you is 111 Retrieve You Circle. This guy looks like he's up to no good, or he's on drugs or something.
So it looks like he's up to no good, right? Suspicious character, call the number. That's what George Zimmerman was trained to do. That's what he's doing.
He's just walking around looking about. Okay, and this guy, is he white, black, or Hispanic? He looks black.
So that's one of the places the news media edited this 911 to make George Zimmerman look racist. You heard George Zimmerman say he looks black. Did he just spontaneously say that? No, he was asked by the dispatcher, is he white, black, or Hispanic? And George Zimmerman says he looks black. But when you take out the question, which is what the news media did, it sounds like George Zimmerman has some independent interest in the race of Trayvon Martin. Well, that's what a racist would do, isn't it? Completely changes the context of the response when you don't know it's a response to a question, but it was.
Did you see what he was wearing? Yeah, a dark hoodie, like a gray hoodie, and either jeans or sweatpants and white tennis shoes.
One of the part of the lore of the racial grievance industrial complex about this case is that George Zimmerman shot Trayvon Martin because he was wearing a hoodie. We just heard Zimmerman say he was wearing a hoodie. Again, was that a spontaneous interjection by George Zimmerman? Does he have in his own mind some special fear of people in hoodies? Or was he just asked by the dispatcher to provide a description of the person's clothes? The answer, of course, is that he was just asked to provide a description of the person's clothes. That's why he mentions the hoodie, not because he thinks everyone in a hoodie is a racist monster.
He's seen around. He was just staring. Oh, he's just walking around the area at all the houses. Okay. Now he's just staring at me.
He's looking around all the houses. Now he's just staring at me. So Zimmerman's in his car. Trayvon Martin realizes now that Zimmerman has him under observation. Zimmerman's on his phone. That's not good for Trayvon Martin. So Trayvon Martin is staring him down. He's walking around Zimmerman's car, staring at him to intimidate him, to frighten him.
Okay, it's 1111 Retrieve You or 111? That's the clubhouse. That's the clubhouse. Do you know what he's near the clubhouse right now? Yeah, now he's coming towards me. Okay.
Now he's coming towards me. So Zimmerman's sitting in his car. He's not advancing on anybody. But Trayvon Martin is advancing on him, eyeballing him the whole time.
He's got his hand in his waistband.
He has his hand in his waistband. To suggest he's got a weapon?
Yeah, he's a black male. Okay. How old would you say he was? He's got a button on his shirt. Late teens. Late teens, okay. Mm-hmm.
Late teens. which is right. 17 years old is how old Trayvon Martin was. He was not this person, right? He was this person. He was this person. That's who Trayvon Martin was dealing with.
Something's wrong with him. Yeah. He's coming to check me out.
He's coming to check me out. Is this intimidating behavior on the part of Trayvon Martin? Is this the behavior of this person? Or is it the behavior of this person? The street fighter? Of this person? Of this person? Of this person?
He's got something in his hands. I don't know what his deal is. Okay, just let me know if he does anything over here. Yeah, we got him on the way. Just let me know if this guy does.
So police are on the way. The dispatcher has dispatched a patrol car. What kind of malice murderer, racially motivated murderer, calls dispatch and asks them to send out a patrol car just before they commit that malice murder? Does that make any sense to anybody?
Anything else? Okay. These assholes, they always get away. Yeah.
Let me rewind it a bit.
Yeah, we got him on the way. Just let me know if this guy does anything else. Okay. These assholes, they always get away.
These assholes, they always get away because they had always gotten away. George Zimmerman had been part of Neighborhood Watch for some time. He'd called the police previously on other suspicious characters, and they always got away. This is frustration. Is there anything wrong with feeling frustrated about that circumstance?
Yeah. When you come to the clubhouse, you come straight in and make a left. Actually, you would go past the clubhouse. Okay, it says on the left-hand side from the clubhouse? No, you go in straight through the entrance, and then you make a left. Yeah, you go straight in, don't turn and make a left. Shit, he's running. He's running? Which way is he running?
He's running. So Trayvon Martin sees he's under observation, sees George Zimmerman's on his phone. He knows what's happening. George Zimmerman is calling for the police. Trayvon Martin does not want to be there when the police show up. So he runs. He runs behind a building, out of sight. And the dispatcher says, where's he running to?
Oh, shit, he's running. He's running? Which way is he running?
Well, George Zimmerman can't see through a building, so he can't see where Trayvon Martin's running to from his spot in his vehicle. So what does George Zimmerman do? He gets out of his vehicle to walk to the corner of the building, to look around the edge of the building so he can perhaps answer the dispatcher's question. This is when George Zimmerman gets out of his car. Has he been told yet, don't get out of your car? No. So the lie that George Zimmerman got out of his car after being told not to get out of his car by the dispatcher is an utter lie. The lie is exactly that. It is a lie.
Down towards the entrance of the neighborhood.
So George Zimmerman's, he's opening and closing his car door as he gets out. He's walking to the corner of the building. Is he talking in a confrontational way? Is he running? Is he panting?
Okay, which entrance is that he's heading towards?
And he's still talking to the dispatcher. He's still engaging, answering questions.
The back entrance. Are you following him? Yeah. Okay, we don't need you to do that.
So the dispatcher can hear wind noise on George Zimmerman's phone, suspects maybe he got out of the car. Are you following him? George Zimmerman says yes, meaning he's following the same path of direction to look around the corner of the building. And the dispatcher says, we don't need you to do that. And what does George Zimmerman say? Does he say, F you, I'm going to run this guy down? F you, I'm going to give him what he deserves? Is he non-compliant with the dispatcher? Does he disobey the dispatcher's order? By the way, the dispatcher would testify at trial in court and say, I don't give orders to people who call us on the phone because I don't know what's actually going on there. I'm here at my computer terminal. So I would never give an order. It's not a legal order. This dispatcher wasn't even actually a police officer, as they often aren't. So there was no order given. But a suggestion? We don't need you to do that. Not don't do that. We don't need you to do that, is what the dispatcher says. And what does George Zimmerman say? This malice murderer, this racist murderer of a child over Skittles and iced tea?
Yeah, okay, we don't need you to do that.
No.
Are you following him?
It's hard to hear, but what George Zimmerman says in response to that is okay. And he starts walking back towards his vehicle.
Yeah, okay, we don't need you to do that. All right, sir, what is your name? George.
Now, George is whispering now because he saw Trayvon Martin run around the corner, but now he can't see him. And this was, when you run around the corner, there was a long stretch like a dog walk with a sidewalk between two parallel buildings. So you would think when you turn the corner, if someone was running away, you'd still see him running. But George Zimmerman doesn't see anybody running. He doesn't see Trayvon Martin disappeared. So where is he? Now there's a danger. There's this suspicious character, had his hand in his waistband, was eyeballing you, approached your vehicle, fled when he realized you were calling the police. There's danger there. And suddenly you have no idea where this guy is. You thought he was running away, which would be safe enough, but now you can't see him anywhere. So now George Zimmerman is whispering. He's concerned.
George. He ran. All right, George, what's your last name? Zimmerman. And George, what's the phone number you're calling from? 407-435-2400.
That's how you know the call I'm playing for you is completely unedited, because even that was bleeped out during the trial, the phone number.
All right, George, we do have them on the way. Do you want to meet with the officer when they get out there? Yeah. All right, where are you going to meet with them at?
George wants to meet with the officer when he gets out there. Is that what a malice murderer does? He calls the police to come to the scene, and then he arranges to meet with the officers before he shot anybody? What, so they can coordinate their killing of Trayvon Martin? Is that what we're supposed to believe?
If they come in through the gate, tell them to go straight past the clubhouse and straight past the clubhouse and make a left. And then they go past the mailboxes. You'll see my truck. Okay, what address are you parked in front of? I don't know. It's a cut through, so I don't know the address. Okay, do you live in the area? Yeah. What's your apartment number?
So now dispatch asks Zimmerman for his apartment number. Zimmerman doesn't want to provide it, not because he's trying to keep it from the dispatch. Obviously, he's planning to meet with police when they get to the scene. Zimmerman doesn't want to say it out loud on his phone because he's afraid Trayvon Martin might be close enough to overhear his address. And he doesn't want the suspicious dude to hear where he lives.
It's a home. It's 1950. Oh, crap. I don't want to give it out loud. I don't know where this kid is.
I don't want to give it out. I don't know where he is.
Okay, do you want to just be with him right near the mailboxes, then? Yeah, that's fine. All right, George, I'll let him know to meet you with you out there. Okay? Actually, could you have him call me and I'll tell him where I'm at? Okay, yeah, that's no problem.
Has there been a more cooperative call to dispatch than George Zimmerman's call right here?
You need my number? You got it? Yeah, I got it. 407-435-2400. Yeah, you got it. Okay, no problem. I'll let them know to call you when they're in the area. Thanks. You're welcome.
And that is the call of a supposed malice murderer. It was shortly, seconds after George Zimmerman hung up that call, that he was approached by Trayvon Martin, who punched him in the face, knocked him down, mounted him, beat him, ground and pound style, as observed by eyewitnesses who testified at trial. Now, nothing that George Zimmerman did in that entire phone call was illegal. None of it. Now, was it tactically stupid? Yes, it was tactically stupid. George Zimmerman, with the best of intentions, to answer the dispatcher's question, where did he run to observe around the corner of the building, got out of his car. And when he did that, he put himself in an ambush position and he got himself ambushed. And I promise you, George Zimmerman would never make that mistake again. I've been in that situation. I've been driving my car through my local town, saw a fight in the parking lot of a bowling alley, the local bowling alley. And 3 or 4 guys dragged a dude out of a car, were beating him up. So I stopped my car at the far end of the parking lot, maybe 100 yards away. I could see it through my windshield. And I knew my local police station was 3/4 of a mile away from the scene. So I called 911. I said, hey, you may want to send a car out here because the guy's getting his ass beat in the parking lot. He said, I said, he got pulled out of his car and they're beating him up. And I said, well, can you see the license plate of the car? And I said, no, I can't see it from where I am. And they said, well, can you get closer? Can you get closer? I'm carrying a gun on my person, as I did every day as an adult in Massachusetts with a concealed carry permit, believe it or not. I'm not getting closer to anything. No, I told her. I'm not getting any closer. You guys are a mile away. Just get a car here is what you need to do. This is not my job. This is your job. Precisely because I didn't want to risk getting engaged in the conflict myself, potentially having to go to my gun, shooting somebody, and ending up in a George Zimmerman type of situation. All right, so far it's taken us an hour to get through the first substantive sentence of this stupid law review, but let's continue. Trayvon was guilty of nothing more than walking while black in the gated community. Really? Really? What a lie. What a lie. And this professor knows it's a lie. I know from some of what this professor's written that he watched at least some of the trial. He knows that eyewitness testimony at trial was Trayvon Martin was mounted on George Zimmerman, beating him into the ground. He's seen the photos of George Zimmerman's facial injuries. Or if he hasn't, he's literally incompetent to be writing this law review piece. No? Okay, reflecting back a decade later, what is the legacy of Trayvon Martin's case? A teenage life violently cut short, and a legal system that accepted his death without consequence. Was there no consequence? Was the murder trial of George Zimmerman the destruction of his life? Was that not a consequence for George Zimmerman? I think Zimmerman would disagree with this assessment. Among other things, there is the Trayvon generation. We already spoke about this nonsense a bit. I'm going to skip over that because that's not really about the trial. I begin, says Professor what? Brodin? Brodin. I begin with a close look at the Zimmerman trial. Oh, yeah? Expanding on my earlier Harvard Law Journal article. Oh, I should have looked that up. I didn't notice that. With new access to an official audio-visual transcript. That audio-visual transcript of the trial has been available since the trial, folks. I watched the trial live while it was live streaming, and those videos are still available on YouTube. This is not new. I guess he needed an excuse for the editors. Why are we covering this now? This was 10 years ago. Then I put the case in its historical context. That's all just historical racial grievance, industrial complex propaganda. American tradition of vigilantism and its incarnation in the neighborhood crime watches like Zimmerman's. How is that vigilantism? Vigilantism is acting outside the bounds of the law, taking the law into your own hands. There's no evidence Zimmerman did anything like that. Vigilantism is the Punisher, which is why I discourage you from putting those Punisher backplates on your Glocks or stickers on your car. It could be argued by a prosecutor. It goes to your state of mind that you're someone who's prepared to use force outside the legal limits. But there's zero evidence that Zimmerman did anything like that. Next, I contrast the response of the legal system to black as compared to white self-defense in notable cases. I don't cover those here, folks. That's all anecdotal nonsense anyway. Anybody can cherry pick cases and then mischaracterize them, as he's doing here with the Trayvon case. The trial. How is it that an unarmed black youth is shot dead and the civilian shooter walks free? Perhaps black lives don't really matter. Maybe it was because the black youth was beating the civilian shooter to death, smashing his head into a sidewalk and then attempting to relieve the civilian shooter of his gun? Maybe that's why. Maybe Trayvon Martin wasn't unarmed. Maybe he was in the process of arming himself. And that's how he got shot. Florida prosecutors brought charges against George Zimmerman for the fatal shooting only after nationwide protests, 6 weeks after the killing. I explained all this to you already, right? That the local prosecutors saw nothing inconsistent with self-defense, was not going to charge, succumbed to political pressure over a period of weeks by Benjamin Crump, by Al Sharpton. I believe Jesse Jackson was there too. And Angela Corey was brought in from out of jurisdiction to be a special prosecutor in this case. The local police treated Zimmerman more as a victim than a murderer. Well, because the evidence supported that Zimmerman was a victim. He was a victim of Trayvon Martin's attack. And the jurors apparently agreed when they rendered their not guilty verdict. Buried along with Martin was the racial dimension of the case, kept out by the prosecution, the judge, and the defense, except, as we shall see, when it was used to their advantage by instilling fear in the female jurors. All right, why was the quote, racial dimension kept out of the case? So George Zimmerman was charged with malice murder, second-degree malice murder. Malice means there's some special hatred for the person against whom you used force. It could be like a hate crime. And that's what they were trying to suggest, that this was racially motivated by Zimmerman. In fact, in the information, the charging document that they used to drag Zimmerman into trial, the information says under oath that George Zimmerman racially profiled Trayvon Martin. Well, if there's evidence of that, then, I mean, one way to have malice, of course, is to have a pre-existing animus with the person, two people who know each other and have, troubles going back in time. There could be existing personal animus. But another way to have malice is to have generalized malice, right? A racist hates black people. He has generalized malice against black people. That's what they claimed in the charging document when they claimed that George Zimmerman racially profiled. That's why they had the version of the 911 call where they took out the question from the dispatcher, is he black, white, or Hispanic, and made it sound like George Zimmerman spontaneously brought up race to generate false evidence of this false claim of racial profiling. Once you have the claim of racial profiling, then you have an apparent basis for malice murder, right? The racism. I can tell you that the FBI, under the Eric Holder, Barack Obama Department of Justice, sent dozens of agents, I think it was 40 agents, to this apartment complex to interview Zimmerman's neighbors, to try to dig up any suggestion of racism on the part of Zimmerman. We already know that the racial profiling thing was garbage. But was there any other existing evidence of racism? Did he use the N-word? Did he argue, particularly with his black neighbors? Did he have a Confederate flag T-shirt in his closet, or a sticker on his car, or a license plate frame? They couldn't find anything. In fact, what they found was negative racism. The black people in George Zimmerman's community loved him. He helped them around their apartments. He helped carry in groceries. When one of them got robbed, a black woman, elderly black woman, who would testify at trial on behalf of George Zimmerman, when her apartment got robbed through the sliding glass door being jimmied, George Zimmerman helped install a more secure lock on her door so she'd feel safe in her apartment. Again, she testified about this at trial. When George Zimmerman was a child, he and other black children in the community would all gather at his home where they would be tutored by his mother. When a black suspect in the community was, in George Zimmerman's eyes, abused by the police during an arrest, George Zimmerman organized protest against the Sanford Police Department in favor of this black suspect. He wasn't just not racist. He was unracist. He was negative racist. And that's why, by the way, the Department of Justice never brought any kind of civil rights violation charges against George Zimmerman, because there was zero evidence of racism on the part of George Zimmerman. If anything, the opposite. So buried along with Martin was the racial dimension of the case. Why was it buried? Because there was no evidence, folks. And if there's no evidence to support a claim, a fact, an allegation, it doesn't exist for legal purposes. Everything that's raised in court has to have some evidentiary foundation. There was no evidence of racism. So there was no racial dimension. He characterizes this, Professor Brodin, as somebody made an affirmative decision to hide the racism here. There was no racism. That's why it didn't exist. That's why it wasn't in court. The killing, the trial, the acquittal, and the aftermath have reshaped the American landscape, giving rise to the Black Lives Matter movement. George Zimmerman was described in the media. By the way, the media was entirely hand in glove with Benjamin Crump, Al Sharpton, Jesse Jackson driving this racist propaganda. The media did things like edit that 911 call to take out the question about race. So it sounded like George Zimmerman spontaneously offered it. The media did things like took a photo of George Zimmerman in prison garb and lightened his skin to make him look more white than Hispanic. By the way, here's a bit of irony for you. So George Zimmerman, after he was acquitted, sued the media for defamation. At his criminal trial over the killing of Trayvon Martin, the judge there was Judge Deborah Nelson. And she was, in my view, highly biased against the defense. Almost always affirmed the state objections and overruled the defense objections. Excluded a ton of evidence that could have been let in that was exculpatory for George Zimmerman. So, in my view, she was very, very biased against George Zimmerman. Well, in Florida, at least at that time, the judges would flip from criminal court to civil court and back again. They would take turns in each. So when George Zimmerman sued NBC and other news media over their defamation, guess who the trial judge was in that civil suit? It was Judge Deborah Nelson, the same woman who had been the biased judge in his criminal trial. And you know what Deborah Nelson said? She said, well, George, I'm going to dismiss your lawsuit against the media because you're a public figure. Like he chose to be a public figure. Like he wasn't made a public figure by the system and the media and the racial grievance industrial complex. And that's why George Zimmerman wasn't able to sue the media over their obvious, undeniable defamation of his character. Unbelievable. By the way, Judge Deborah Nelson gets even worse. So years later, George Zimmerman was on his way to a doctor's appointment. And of course, he's been completely demonized by the media. And he's riding in the passenger seat of a car, being driven by somebody else to a doctor's appointment. And a lunatic in another vehicle sees him, recognizes him, gets out a gun and shoots at George Zimmerman's head. Misses his head. The bullet hits the car, but misses George Zimmerman. That guy, the shooter, would be arrested, charged with attempted murder at trial, found guilty at trial, a trial in which George Zimmerman testified as a witness against the shooter, who was the defendant in that case. And guess who the trial judge was in the trial of the guy who tried to put a bullet in George Zimmerman's brain? It was Judge Deborah Nelson. Again, she probably thought she could never get away from George Zimmerman. Okay, George Zimmerman was described in the media as Hispanic, but looking white. Is that a fact or is that just media propaganda? But it's presented here as fact. And was identified as white in the Sanford police report of the shooting. He joined, if you see George Zimmerman's parents, they're quite dark-skinned, Central American. He joined the neighborhood crime watch at his gated community. Retreat at Twin Lakes, that's the name of the apartment complex, organized by a volunteer coordinator for the Sanford Police Department. This would be the woman liaison at the police department who I mentioned earlier, who was already overseeing at least 10 such groups. So she did a lot of this, and she testified at trial. She was quite good testimony. She came across very well. In her PowerPoint presentation and the handbook she distributed at the initial meeting, which were introduced into evidence at trial, she emphasized that the watch volunteer's role was being the eyes and ears for the police, but not the vigilante. Well, what did George Zimmerman do here? We heard it on the 911 call. He was the eyes and ears of the police. Is there any evidence that George Zimmerman did anything outside the boundaries of the law? No. The motto is we look out for each other. Citizens participating in the Neighborhood Watch program are not law enforcement officers and should never attempt to apprehend a suspect. This is all quoting from the manual. the Neighborhood Watch Manual. Did George Zimmerman attempt to apprehend a suspect? Is there any evidence of that? No. No evidence of that presented at trial. Should never attempt to apprehend a suspect. This is a law enforcement officer's job. Who did George Zimmerman call on the phone to get out there? A law enforcement officer. Members of a neighborhood watch are not supposed to confront anyone, she warned. Any evidence that George Zimmerman confronted anybody? No. But by presenting all this in this manner, what is Professor Brodin trying to suggest? He's implying that these must be things that George Zimmerman did, and look, he wasn't supposed to. He'd been told not to do any of these things. In fact, there's no evidence he did any of these things. We, the police, get paid to get into harm's way. You don't do that. You just call them from the safety of your home or your vehicle. This is not about being a vigilante police force. You're not even supposed to patrol a neighborhood, and you're certainly not supposed to carry a gun. But are you allowed to carry a gun? Did George Zimmerman have a concealed carry permit? Was he charged with a gun crime in this case? Because it was unlawful for him to have the gun on his person. Nope. Perfectly lawful. Now, Neighborhood Watch might prefer you not have a gun on your person, but that's not a condition of being on Neighborhood Watch, and you're not prohibited from having a gun if you're otherwise lawfully permitted to have a gun on your person. Zimmerman was chosen as watch captain without either a background check or training. Well, this is a lie. It's an outright lie. First of all, the fact that he was chosen by his community as watch captain is a testament to their positive view of George Zimmerman, right? He didn't have a background check. Was a background check required? Did anybody in Neighborhood Watch have a background check performed? No. So this is a red herring. And without training. He was trained by this woman with her PowerPoint that we just talked about. He had training. He had been rejected from at least one police department to which he applied. Well, he was unfit when he applied. He was fat. That's why he was in the gym getting in shape. It wasn't a reflection of his moral character or his judgment. The 4 911 calls reporting suspicious persons that Zimmerman had made in the months before confronting Martin, in other words, doing his job as Neighborhood Watch, were also young black males, none of whom were arrested because they always get away. That's why they weren't arrested. And as we've noted, 60% of violent crime in America is committed by the 5% of the population that is young black males. They commit a disproportionate amount of crime. So is it any surprise that he was calling about young black males? Or is it possible, statistically consistent, that young black males in this community were committing a disproportionate percentage of the crimes? There would be a woman who would testify at trial about hiding in her closet with her 2 children with a gun in hand while home invaders were ransacking her home. And they happen to be young black males too. Was she also a racist? On February 26th, 2012, he again dialed 911 from his vehicle to report the black high school student as someone who looks like he's up to no good or he's on drugs or something. It's raining and he's just walking around looking about. That's the 911 call we just listened to. Trayvon, described by witnesses as a baby-faced little boy. What witnesses? What's the baby-faced little boy? Is this the baby-faced little boy? This one? Is this the baby-faced little boy? Huh. Is this the baby-faced little boy? Is this the baby-faced little boy? You're contemptible, Professor Brodin. You horrible, racist firebrand. For shame, sir. For shame. Trayvon, described by witnesses as a baby-faced little boy and referred to by the police detective who interviewed Zimmerman as the child. Well, technically, he was a child. He wasn't an adult. He was 17 years old. As a child he killed, was walking with his hoodie up for the rain and carrying a bag of Skittles and an iced tea while talking to friend Rachel Jeantel on a cell phone. Is that why Zimmerman shot him? Did Zimmerman say, I shot Trayvon Martin because he was walking with his hoodie up and carrying a bag of Skittles and iced tea and talking to Rachel Jeantel? who, by the way, if you haven't watched the trial, the Zimmerman trial, if you look at No Other Witness, watch her testimony, Rachel Jeantel. Zimmerman complained to the 911 dispatcher, effing punks, these a-holes, they always get away. We heard that. Did we hear his tone of voice? The frustration? Because they always did get away. As the gated community reportedly was 20% African Americans, what apparently triggered Zimmerman's attention was Trayvon's race combined with his youth and attire. Is that what Zimmerman said on the 911 call? What bothers me about this person is his race, his youth, and his attire? Or was it that this person looks suspicious, that they're eyeballing me, that they're closing proximity in my vehicle, that they have their hand in their waistband, that they're 6 feet something tall, that they're acting in a threatening way, that they're fleeing when they suspect I'm calling the police? Commentators, whoever that is, noted that the hoodie closely associated with racial profiling. Was there any evidence of racial profiling here? Nope. May have cost Trayvon his life. Maybe what cost Trayvon his life was his decision to attack an armed man. Zimmerman apparently, when they use the word apparently here, that means they have no evidence, or they would point to the evidence, right? They're just making shit up. Zimmerman apparently believed he had a sixth sense, touted as the key neighborhood watch skill to instinctively know when something is not right. Who said that? Footnote 55. Muskell and Sussman, neighborhood watch skill. So it's some kind of neighborhood watch training thing. Is there any evidence that Zimmerman possessed this state of mind? No. None. That's why they have to say apparently. The probable cause affidavit, this is actually, the information is the correct word for this, but the probable cause affidavit ultimately charging Zimmerman with second-degree malice murder asserted that Zimmerman had profiled Martin and assumed Martin was a criminal because he did not belong in the gated community. The information did say that Zimmerman profiled Martin. That was the foundation for the malice murder charge. Was there ever any evidence of profiling, or was the information lying under oath? It was lying under oath. And in my opinion, if you're dragged into court, into trial, on a false information, a false probable cause affidavit, or a defective grand jury indictment, that trial should be dismissed with prejudice, because it's not the defendant who lied in the information. It's the prosecutor and her investigators who lied under oath in that information. Racial profiling, my ass. It never happened. I can assure you, if they had any evidence of racial profiling, we would have heard that a million times over. Trayvon was a person of color in a modern sundown town, and Zimmerman was the sheriff. What is this? This is the work of a law professor, this estrogenic hyperbole? You pathetic. Professor Brodin, for shame, sir. That the latter, Zimmerman, identified as Hispanic, in no way immunizes him from racial stereotyping. Well, frankly, folks, I think everybody racially stereotypes to one degree or another. I think it's built into our DNA. What good people do is they don't let that influence how they interact with others. He's just a human being. As if this Professor Brodin is immunized from racial stereotyping. Armed with a 9mm semi-automatic handgun. So this was a Kel-Tec 9mm, which the prosecutor throughout the trial would refer to as a Kill-Tec, not a Kel-Tec, but a Kill-Tec pistol, loaded with lethal hollow point ammunition. Anybody want to describe for me the 9mm ammo that's non-lethal? No? It's all lethal. Is this the same hollow point ammunition that the police who came to the scene were carrying? Yes. Armed with a 9mm semi-automatic handgun loaded with lethal hollow point ammunition in violation of the rules of his neighborhood watch. Does that make it a crime? Was Zimmerman charged with a gun crime in this case? No. Nope. And against the explicit instructions of the 911 dispatcher, Zimmerman pursued, confronted, and fatally shot Trayvon Martin through the heart at point blank range. Look how they go fast now. They put all these words in because half of them are lies. Some of them are true. So they want to blur in the lies with the truth. So you just think it's all true. I'll read the sentence in one run. See how long of a run-on sentence this is. Armed with a 9mm semi-automatic handgun loaded with lethal hollow-point ammunition in violation of the rules of his neighborhood watch and against the explicit instructions of the 911 police dispatcher, Zimmerman pursued, confronted, and fatally shot Trayvon Martin through the heart at point-blank range within a minute's walk of his father's location in the Twin Lakes retreat. How do you know it's a lie? Just listen to it. Is there any evidence that Zimmerman pursued anybody? You can't pursue something you can't see. There's no evidence that he saw Trayvon Martin after Martin fled around the building. He would have said that on the 911 call, right? Oh, there he is. There's no evidence he pursued anybody. Is there evidence that Zimmerman confronted Trayvon Martin? No. The evidence is that Trayvon Martin emerged from hiding and confronted George Zimmerman. Did he fatally shoot Trayvon through the heart? Yes, of course, because he was defending himself against Trayvon Martin. Within a minute's walk of his father's, this is Trayvon Martin's location. So his father didn't live there either, but his father's current girlfriend lived there. And Trayvon Martin was staying at the current girlfriend's house because he'd been kicked out by his mother. Trayvon Martin had been kicked out of his mother's house because he got suspended from school for having all that stolen jewelry in his locker. But it is worth noting that Trayvon Martin was only about a minute away, less than a minute if he was running, from a position of safety, from the apartment he was staying in. So why wasn't he there? Because it took more than a minute between when George Zimmerman says he's running to getting off the phone with dispatch and then getting attacked by Trayvon Martin. That took more than a minute. So if it only took a minute for Trayvon Martin to get home, why didn't he just run home if he was scared of George Zimmerman? Zimmerman had never identified himself to his victim as a neighborhood watch captain. Well, he never saw his victim until his victim attacked him. Even when Trayvon asked, as testified by his friend on the cell phone call, "Why are you following me?" So this friend was Rachel Jeantel. And if you want to know how incredible, literally incredible, unbelievable, obvious lies her testimony was, you need to watch her testimony. By the way, this is where they got this information. She was discovered kind of late, Rachel Jeantel, in the investigation. Very, very heavy-set young black girl, supposedly Trayvon's girlfriend. And this was part of the propaganda. Oh, his girlfriend listened to him die on the phone. The Benjamin Crump crowd went out to her and got her, they said, to write out a statement of what happened on a piece of paper. And part of that statement, that written statement, was that Trayvon Martin had asked George Zimmerman, "Why are you following me?" Well, of course, if Zimmerman had been following Trayvon Martin, that would look like pursuit. That would look like confrontation. That might be inconsistent with self-defense. But when Rachel Jeantel was put on the witness stand at trial, and Don West presented her with her note, her supposed note, where she wrote out these words, and he asked her to read it aloud to the jury, you know what Rachel Jeantel said? She said, "I can't read this. It's in cursive. I can't read cursive." So obviously she did not write that note. Someone else wrote that note, and then they claimed it was Rachel Jeantel. You don't have to lie like this, folks, if you have the truth to tell. Continuing now with contemptible Professor Brodin, Zimmerman was on a mission. This punk was not getting away on his watch. Any evidence of that? Any at all? No. And so Trayvon experienced what the prosecutorial trial called a child's worst nightmare, being chased in the dark by a menacing stranger. Was there a chase here? No. How menacing was George Zimmerman? He wasn't running around with a gun in his hand. There's no evidence that George Zimmerman ever saw Trayvon Martin from the point of flight until the point where Trayvon Martin ambushed him. The lead detective on the case asked Zimmerman, did it ever occur to you to go ahead and ask this person what he was doing out there, observing that if you had, we probably wouldn't be here right now? But the whole point of Neighborhood Watch was they tell you not to confront, right? So George Zimmerman was trained not to do this. And by the way, this detective, who was a very nice guy, he's interrogating Zimmerman in the immediate aftermath, the night hours after the shooting, and he's trying to break Zimmerman's story. This doesn't reflect what the detective may have genuinely thought about the case. This reflects the detective applying interrogation techniques to shake Zimmerman's story. Was he ever able to shake Zimmerman's story as self-defense? This trained, professional interrogator dealing with George Zimmerman, who I like a lot as a person, but let's face it, not the smartest guy on the face of the planet. Nope, never. In fact, at one point, the detective did something that interrogators are allowed to do in law enforcement. They lied to Zimmerman about the evidence they had. They came to Zimmerman and they said, listen, we have a serious problem with your story as self-defense. You have to tell us the truth. We have evidence that it wasn't self-defense. And George Zimmerman said, what do you mean? And the detective said, well, we found a video camera that caught the whole thing on video. And you know what George Zimmerman said? He put his face in his hands and he said, thank God. Because he knew that video would be exculpatory. Now, unfortunately for Zimmerman, it was a lie. There was no video because the video would have been exculpatory. But that's the lengths to which this detective, just doing his job, I'm not criticizing him. By the way, he would die of a drug overdose just months after this trial. They demoted him from detective to police sergeant or uniformed officer during this trial. He testified twice, once for the state where he was dressed as a detective, and then once for the defense later in the trial, and he was in a uniform. They demoted him because they didn't like how he was testifying. Because it was favorable to the defense, as the whole trial was. Chris Sereno was his name. So he was just doing his job. But the words he's saying in the interrogation are not evidence. That's him trying to break a suspect of their self-defense story. The detective noted that Martin wasn't a violent kid. Well, the detective didn't know Trayvon Martin. He's just saying this. He's saying these words. In fact, Trayvon Martin was a violent kid. How do we know? We know because we have pictures like this, and we have text messages of Trayvon Martin being violent, engaging in voluntary street fighting. That's how we know. And that's why these statements by the detective in interrogation are not evidence. By the way, this detective testified at trial, as I said, both for the state and the defense, and he never repeated any of this as evidence at trial. The detective noted Martin wasn't a violent kid, wasn't on drugs. My recollection is that Trayvon Martin tested positive for drugs, but it wasn't admissible as evidence because it wasn't known to George Zimmerman at the time, so it wasn't relevant to Zimmerman's state of mind. Wasn't involved in any criminal activity. We know Trayvon Martin was involved in criminal activity. He was suspended from school for having stolen property, jewelry in his locker, and had every right to be there and to defend himself. These are just words this detective is saying. None of this is true. Why is Professor Brodin presenting this as if these were facts when they're not facts? Why, Professor Brodin? You contemptible, propagandizing liar. The police interview with Zimmerman that night and in the days following, Zimmerman, by the way, always spoke with police in these interviews, these series of interviews over days in the aftermath of the shooting without legal counsel present. Every time the police called him to come in and give another statement, he came in. The days following look more like defense preparation than police interrogation. The detective asked Zimmerman, had Martin been a goon, a bad kid, 2 thumbs up, but he does not fit the profile of what occurred, which is another unfortunate thing that we got going here. Again, these are just statements in interrogation intended to shake Zimmerman's story, to test it. None of these are facts. It's clear whose side the Sanford police were on. Is it? Maybe they were on the side of the person who defended themselves. Maybe if that had been Trayvon Martin, they would have been on Trayvon Martin's side. But maybe if the evidence suggests George Zimmerman was the victim of a crime, the police are supposed to be on the side of the person who's the victim of a crime. It's clear whose side the Sanford police were on. If there's any doubt, the detective closed the interview, quote, "We're working for you. We've got to open your mind. And if there's anything that needs to be changed, this is it." Again, these are just interrogation words to try to shake George's story, to get him to open up, to say things that might be inconsistent with his claim of self-defense. Did that ever happen? Was there any evidence from George Zimmerman inconsistent at any time with his consistent claim of self-defense? No. The Sanford police treated Zimmerman almost like one of their own. You mean when they handcuffed him in the back of the police car? Police witnesses during the trial would refer to the defendant as George. Zimmerman referred to Trayvon as the suspect in his written statement to the police, and they acted accordingly. Well, why not? Trayvon was acting as a suspicious person. After the softball interview, which wasn't softball, they worked pretty hard to break Zimmerman's story of self-defense, but you can't break a story that's true. After the softball interview, this man who had just fatally shot an unarmed teenager was released without further investigation. Maybe because his face was bloodied, the back of his head was bloodied. Maybe because eyewitnesses gave statements that Trayvon Martin was mounted atop George Zimmerman, the position of the aggressor. The police accepting his version of events, which he reenacted on video with them the next day. So again, George Zimmerman went back. He went to the scene. They asked him to come. And they said, "George, can you kind of walk us through what happened while we recorded on camera?" And George Zimmerman did that without lawyer present. And it was entirely consistent with what he'd been saying the entire time. Having successfully eluded Zimmerman's pursuit, he claimed, well, Zimmerman never claimed that somebody eluded his pursuit because Zimmerman never claimed he pursued anybody. More lies from Professor Brodin. You contemptible legal hack. Boston College Law School. You should be ashamed of yourselves for employing this guy. Having successfully eluded Zimmerman's pursuit, Zimmerman claimed, Martin suddenly jumped out from behind bushes, punching the much larger adult in the nose, tackling him, banging his head on the sidewalk, suffocating him, and screaming, "You're going to die tonight." Well, we have physical evidence consistent with much of this. We have the text messages from Trayvon Martin on his phone saying this is his preferred attack technique. A surprise punch to the face, get him on the ground, mount him. We know he was banging Zimmerman's head into the sidewalk because we have the back of the head injuries. That's from the sidewalk. We know he punched Zimmerman in the face because we have these images taken moments after the scene by the police before Zimmerman was cleaned up at the police station. So there's actually evidence to support Trayvon Martin's story. Punching the much larger adult in the nose. No, George Zimmerman was not much larger. He was shorter by a substantial amount than Trayvon Martin. And he wasn't nearly as heavy at the time of the attack by Trayvon Martin as he was at trial. Then Martin, on top of Zimmerman, I guess the professor's buying into that. At trial, they made a big argument that, wasn't it Zimmerman on top of Martin? Nope, eyewitness. The one in the hoodie, not the one in the orange jacket. Zimmerman was wearing an orange jacket. The one in the hoodie was on top. That was Trayvon Martin. On top of Zimmerman, supposedly reached for Zimmerman's gun hidden in a holster at his back. It wasn't at his back. It was at his side. And under his shirt, the jacket and shirt had been pulled open in the course of the struggle, leaving Zimmerman no choice but to shoot Trayvon in self-defense. After suffering the close-range fatal bullet wound through his heart, Martin, according to Zimmerman, was nonetheless able to yell, "You got me," before dying. Expert testimony from the medical examiner trial made such an exclamation highly improbable, but this was contested by a defense expert. Well, of course it was, because people get shot in the heart and can still kill people. In the 1980s, there was the Miami bank robbery shootout with the FBI, where one of the bank robberies early in the gunfight gets shot through the heart with a 9mm pistol and kills another 2 or 3 FBI agents in the gunfight after being shot through the heart and mortally wounded. So someone can fight off, kill, overcome 2 to 3 armed FBI agents with a bullet in the heart, but they can't say you got me. Trayvon, of course, had no say in what happened. As Ta-Nehisi Coates put it, your side of the story is irrelevant if you're dead. Is it irrelevant? It seems to me these people are making it very relevant. They're talking about it. The state brought a prosecution on behalf of Trayvon Martin. In the week following, news reports circulated that Martin had traces of marijuana in his blood. See? Positive tox results. No drug screens were performed on Zimmerman. Well, there was no evidence that he was on drugs. We had photos of marijuana on Trayvon Martin's phone. And of course, an autopsy was done where they routinely run the tox. Did Zimmerman ever say you can't test me for drugs? No. Nope. After public pressure, both locally and nationally, these were the mobs, the raging mob of the racial grievance industrial complex fomented by Ben Crump, by Al Sharpton, by Jesse Jackson, by the media. Zimmerman was finally charged with second-degree malice murder in April on the basis of a false information, falsely claiming racial profiling. He was tried before an all-female jury, 5 white and 1 Hispanic. The population of Seminole County, from which the jury was drawn, was 11% black, but no black person sat on the panel. Well, why would that be unusual? 11% would be less than 1 in 6. This was a 6-person jury. So it's not surprising statistically that no black person was seated. Voir dire, jury selection, questioning of potential jurors focused mostly on exposure to media coverage of the case, not its racial dimension, because there was no racial dimension. There was zero evidence of any racial component other than the happenstance fact that Zimmerman was Hispanic and Trayvon Martin was black. There's no evidence of a substantive racial dimension to this case. None. Despite Barack Obama's FBI sending dozens of agents to the scene to try to scrape something up that would look like racism. For strategic reasons, Zimmerman did not formally invoke Florida's stand your ground law. There is no such thing as invoking a stand your ground law. All stand your ground does is relieve you from an otherwise existing legal duty to retreat. Zimmerman would have had no legal duty to retreat on these facts. The duty would only arise when he was contemplating the need to use deadly force, and by then he was on his back, pinned to the ground. No safe retreat was possible. So stand your ground is irrelevant. What this dope, Professor Corbin, means is self-defense immunity law. Zimmerman did not request a pre-trial self-defense immunity hearing. Why not? Well, there's good reason why not. And I talked to Don West, his defense counsel, afterwards and asked him about it. The reasons why not is it was such a politically energized case that it was not realistic to think that any trial judge would be willing to take the political heat of granting immunity. This had to go to trial. The jury had to take the heat if they were going to acquit. Deborah Nelson would never have granted immunity in this case, regardless of the legal merit. Second, this was going to be I'm an expert witness in a murder trial this week, folks. It's going to be a one-day trial. Most murder trials are 1 day, 2 days. That's it. This, we all knew, was going to be a multi-week trial. It's going to be complicated. Lots of nuance, lots of strategy. But the self-defense immunity hearing is basically a mini trial before the trial. So it would also be very long, days long. And in the course of a futile attempt to obtain immunity for their client, the defense would have had to have laid out their entire defense strategy. At the trial itself, keep in mind, the state goes first. They present their case in chief first. So the defense gets the counterpunch. But if you do the self-defense immunity hearing, the state gets to see all your theory of the case, your strategy for trial before they ever get to trial. So when they go first at the trial, they get the counterpunch. Why give them that advantage? That's why self-defense immunity was not pursued. For strategic reasons, Zimmerman did not formally invoke Florida stand your ground law, but it clearly hovered over the trial. What an idiotic thing to say. Even if you mean stand your ground as stand your ground, there was no stand your ground issue here. There was no possibility of safe retreat that needed to be relieved by stand your ground. And if you mean self-defense immunity when you say stand your ground, once you're at trial, self-defense immunity is over. Period. It's a pre-trial event. So it can't hover over the trial. Now, stand your ground did hover in the political sense, where people pretend that it means that you can shoot black people anytime you want. That lie hung over the trial. But that was propaganda. That wasn't law. The product of National Rifle Association drafting and intense lobbying, the law eliminates the common law duty to retreat in the face of danger and provides complete immunity, criminal as well as civil, to a person using force, including lethal, within the parameters of the statute. Those are two different things. The first one is a accurate enough description of stand your ground. The second half of that sentence is an accurate enough description of self-defense immunity. Two different legal doctrines. They're not even in the same statute. These laws, now adopted around the country, Florida's was the first. Oh my God. This is a law professor. You idiot. Florida was the first state with stand your ground. How about California? People versus Lewis. California Supreme Court established there was no legal duty to retreat in California before you could use deadly force in self-defense in an otherwise lawful case of self-defense. When do you think People v. Lewis, California Supreme Court, when do you think that decision came down? Was it before Florida adopted stand your ground in whatever it was, 2005? It was 1897, folks, 1897. Florida was the first state to have stand your ground. You, professor, are adult. A legal dolt. Florida's was the first. Expanded the license for defense of one's castle to anywhere and everywhere. Well, everywhere you have a legal right to be. You were relieved of an otherwise existing legal duty to retreat and otherwise lawful cases of self-defense. By the way, stand your ground is not some weird alternative way to argue self-defense. If there's no stand your ground, you have 5 elements of a claim of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. Stand your ground takes avoidance off the table. You still have the other 4 elements that are required for lawful self-defense. You still have to have been the innocent victim, the non-aggressor, of an imminent, unlawful form of deadly force, and you're reasonably perceiving that threat. If you're the innocent victim of an imminent deadly force threat that you're reasonably perceiving, why should you have to try to retreat before you can defend yourself in that circumstance? Testimony at trial established that Zimmerman, a criminal justice student at Seminole State College, wow, what a killer, was well aware of the law of self-defense at the time of his encounter with Martin and during police questioning afterward. Oh my God, the law professor is suggesting there's something wrong with someone being well aware of the law. How shocking. Remarkably and inexplicably, it was the prosecution that put Zimmerman's version of events before the jury through its own witnesses, recordings of Zimmerman's interviews, and Zimmerman's video recreation of the crime. Well, that's true, but it's not inexplicable. So it was funny watching the trial, watching the state's case in chief, because every state witness, I was thinking to myself, well, surely this witness is going to support the state's narrative of malice murder. But either the state's witnesses just didn't help the state's case, or it was actually favorable to George Zimmerman. And the reason the state presented Zimmerman's interrogation, and his video walkthrough was because if they had not presented it, guess who would have? The defense would have. And the defense would have made it look like the state was trying to hide it. So the jury would have seen the videos anyway. The state simply presented the videos themselves because they thought that was strategically the best place to put it in the trial. The teenager escapes from his pursuit. There's no evidence of a pursuit or an escape. He just hides in an ambush position, but then comes back, jumps from behind bushes, punches Zimmerman, knocks him to the ground, bangs his head on the sidewalk. We have the photo of the injuries, right? We have the photos of the punch to the face, the injuries caused by the punch to the face. knocks him to the ground, bangs his head on the sidewalk, reaches for his gun, holstered on his back waistband. It's on his side. All the while screaming, Trayvon screaming, according to Zimmerman, "You're going to die tonight." And the accused, Zimmerman, was thus relieved of having to take the stand under oath and subject this dubious story to cross-examination. Does the professor not understand that every criminal defendant has the privilege to not take the stand and testify? That the burden's on the state to prove guilt beyond a reasonable doubt. They cannot compel the defendant to testify. Is the professor against the Fifth Amendment to the Constitution? The state's case was further undermined, because it was nonsense, when the judge permitted the defense during its closing argument to show the jurors an animated video with Martin in a hoodie throwing the first punch at Zimmerman. The jurors went into their deliberations with this image in their minds. Well, first of all, that's not the last thing the jurors saw. And this video is offered to the jury as demonstrative evidence. It's not evidence of the event, and it's not presented as evidence of the event. It's an illustration of how the defense thinks things went down. And it's for illustrative purposes. The jury's told it's not direct evidence. This is not like a video recording of the actual fight. And the state got the same opportunity to present its demonstrative evidence. And after the defense showed this video, the state gave a rebuttal closing argument. So the last words the jury heard before they went into the deliberations were the words of the state prosecutors. The prosecution team also failed to object when its own police witnesses were asked on defense cross-examination whether they believed Zimmerman's story, and they answered in the affirmative. So the police witnesses said, hey, when we talked to Zimmerman, we believed he was telling the truth. There was no objection from the state at the time until the next day. After they got to sleep on it at night, this prosecution apparently realized, holy cow, that was really damaging testimony. We want to object, Your Honor, they said the next morning, and we want you to strike that testimony and tell the jury they're not allowed to consider it. This decision by the state was perhaps the dumbest thing they did the entire trial. Because what was the effect? The effect was to make the jury's not going to unhear the testimony. The effect was to double down on the importance of that testimony, to remind the jury that it had occurred. It emphasized those exculpatory statements by the police regarding Zimmerman's credibility. Stupid. The judge struck the testimony belatedly after jurors had a day to absorb it and night, and damage to the state's case had been done. The prosecution deliberately kept race out of the case. Why do you think they did that? You think the state had evidence of racism on Zimmerman's part and just chose to keep it out of the case? No. Race was kept out of the case because there was zero evidence of racism on the part of Zimmerman. Closing with this confusing observation. Quote, race. This case is not about race. It's about right and wrong. Ask yourselves, all things being equal, if the roles were reversed and it was 28-year-old George Zimmerman walking home in the rain with a hoodie on to protect himself from the rain, walking through that neighborhood, and a 17-year-old driving around in a car who called the police, and if it was Trayvon Martin who had shot and killed George Zimmerman, what would your verdict be? That's how you know it's not about race. Close quote. You notice what they left out? They left out the ambush. They left out the punch to the face, knocking to the ground, the beating of the head into the sidewalk, the mounting, ground and pound MMA style attack, the reaching for the gun in the waistband. I wonder why they left that out. The defense and trial judge obligingly cooperated, the former happy to colorblind the story because there was no race evidence in the story, and the latter even forbidding the use of the term racial profiling to describe what happened on February 26th. Why was the jury not allowed to be told there was racial profiling, as the sworn information had claimed? Because there was zero evidence of racial profiling. You're not supposed to just be able to make shit up at trial. There needs to be evidence. The white jurors were also apparently willing to assume that his race had nothing to do with Trayvon's death. Well, there was no evidence of racism. And remember, one of the 6 jurors was Hispanic. The George Zimmerman trial was like telling Noah's story, but leaving out the part about the flood. Isn't that funny? They just recounted all the race stuff from the prosecution, but they left out everything that Trayvon did, right? The ambush, the punch, the mounting, the beating. Is that a little bit like leaving out the flood? The courtroom drama played out without its main character. The racial pathology behind the senseless killing, the irrational fear of the dark other. This is Professor Corbin just making crap up. Zero evidence of any of this. He wants to believe it's true because that's his personal trauma. He's painting his personal trauma, his broken, racist worldview onto this case where there's no evidence of this. Hey, Kurt just popped into the chat. We're just wrapping up, Kurt. Sorry about that. I hope we're wrapping up. I got a haircut in half an hour. The defense team, though, cleverly exploited the racial fears of the all-female jury. Wait, so females are inherently racist? Is that Professor Corbin's position? You legal hack? A young white mother living in Twin Lakes Retreat was called as a witness to tell jurors about how she had cowered in a closet, shielding her baby, as two African-American males burglarized her home months before. It was a home invasion. Zimmerman was aware of this home invasion. That's one of the reasons he found Trayvon Martin suspicious, because young black men had been committing horrific crimes in this community on a routine basis. The prosecution declined to object to this witness, despite the very questionable relevance and demonstrable prejudicial impact of the stereotype of the black male terrorizing a white woman. Was the story true or not? Was Zimmerman aware of it or not? Was it relevant to Zimmerman's creation of a suspicion? Yes. And one of the last exhibits the defense showed the jury was their surveillance camera footage of Trayvon buying snacks in the 7-Eleven prior to his killing, the kind of chilling image of an armed robbery often shown up on the news. This is the image they're referring to here. The reason the defense showed this image was to show how tall Trayvon Martin was. The clerk's 5'10". Trayvon Martin was not this kid when he attacked George Zimmerman. That's the point of showing this image by the defense. They never suggested Trayvon Martin was committing a robbery. You dolt, Professor. The trial judge instructed the jury regarding Florida's generous definition of self-defense. Florida's self-defense statute is in no meaningful way different than the self-defense laws in every other state, folks. Perfectly standard self-defense law. But restricted the jurors' attention to the immediate final encounter between the two, ignoring Zimmerman's stalking and confrontation. There's no evidence of stalking. You stalk prey. There's no evidence Zimmerman was doing that. The state never presented any. There's no evidence that Zimmerman confronted anybody. The evidence is that Zimmerman was waiting for the police he had called to come to the scene when Trayvon Martin ambushed and attacked him. The judge, Deborah Nelson, also declined to inform the jury, as the prosecution requested, that if Zimmerman had provoked the confrontation under Florida law, he forfeited his defense. That would be true, but you don't give instructions in the absence of evidence to support the instruction. And there was no evidence that Zimmerman provoked anything. Given all this, the verdict, not surprisingly, well, lots of people were surprised because they were misled by people like this hack, Professor Corbin. The verdict, not surprisingly, was not guilty on both counts, murder and the lesser included offense of manslaughter. In fact, there were lots of charges. The jury instructions given to the jury were like 34, 35 pages long because the state included every lesser included charge they could fit into the broad permission given by the judge, and the jury acquitted Zimmerman of all of them, not just two. The state even tried to get abuse of a child included as a charge because Trayvon Martin was technically a child, 17 years old at the time. Two jurors subsequently indicated in interviews that stand your ground played a role in their deliberations. Jury interviews after the fact are meaningless, folks, because they just make things up. When they realize they're going to be subject to hostile community pressure, they make up stories about why they arrived at the verdict they did. And they don't, you think the jury knows what stand your ground means when this professor doesn't know what stand your ground means? It apparently did not occur to the jurors that Trayvon, not Zimmerman, was the actor who was compelled to defend himself. This is just a summary statement of fact that has no evidence to support itself. Maybe it didn't occur to the jury that Trayvon was the victim because all the evidence was that Trayvon was the aggressor. It did not occur to conservative Fox News host Sean Hannity in his exclusive interview with George Zimmerman. Maybe Martin was running from you because he was afraid of you and didn't know who you were. Well, that's just a question. That's not evidence of anything. There's no evidence to support that. By the way, if Trayvon had been in fear and run, he would have made it to his apartment. His apartment was only a minute away. And he had plenty of time to get there. He had minutes to get there. During the trial, I actually reenacted this. I had a small child in a stroller at the time, 10 years ago, and I walked around my block the same distance as existed between the scene of the fight and Trayvon's apartment. And me, an old dude pushing a child in a stroller, was able to make that distance in a fraction of the time that Trayvon Martin had. So he was not in fear and running for safety. He would have achieved a position of safety if that were the case. A Georgetown law professor, Paul Butler, spoke for many observers of the case, quote, "If we reverse the races here, a not guilty verdict is impossible to imagine." Well, Paul Butler is apparently an idiot, lacking in imagination. He's just a racist. If the races were reversed, the outcome would be different. There's no evidence to support that. So think about a big black man who followed a skinny white teenager, gets into a fight with him. Who got into a fight, Professor? Or Paul Butler? Who got into a fight? This was not mutual combat. The state never claimed mutual combat. Trayvon Martin was the physical aggressor in this confrontation. How about a big black man who didn't follow a skinny white teenager is attacked by the teenager, 6 foot tall, muscular, with text messages about fighting in this precise manner, kicked out of school for possession of stolen property, positive tox results, text messages about his phone, street fighting. The skinny white dude isn't armed, and the big black guy shoots him dead and then claims self-defense. Does anybody think that a jury would buy that? Yeah, I do. Sure, why not? How could the jurors assess the reasonableness of Zimmerman's self-defense without recognizing that his suspicions about Trayvon most probably were generated by stereotypes and implicit bias against and fear of black youth? There's no evidence of any of this. None. This is Professor Corbin layering his race trauma onto a case. That is bad legal analysis, Professor. It's nothing but racism. And what about the possible bias that jurors themselves may have brought to their deliberations? Where's the evidence of that, Professor Corbin? You racist hack. As one scholar puts it, see, these people have to believe that racism is everywhere or they can't explain their view of reality, their very broken view of reality. And what about let's see, as one scholar put it, Martin's mere presence as a young black man in the predominantly white middle-class gated community had constituted a threat to the sanctity of Zimmerman's and the jurors' expansive castle. Utter projection by these racists. No evidence of any of this. We will come back to these questions below. That's what the bulk of this paper is about. We're not going to cover that nonsense. If you want to read Racist Diarrhea, I'll link this paper in the description to today's show. The jurors apparently dismissed the compelling testimony of Martin's 19-year-old friend, Rachel Jeantel. If you watch that testimony, you will dismiss it too. That was perhaps the worst witness I've ever seen at trial, who was on her cell phone with him during the entire encounter while he was stalked by what he described as a creepy white guy. No evidence of stalking. Over 2 days, often in tears and apparently not adequately prepared by the prosecutors. This is Professor Corbin hand-waving away how horrible a witness she was. This is the girl who said, "I can't read my own note because I can't read cursive." She related Martin's contemporaneous account of his last minutes, pleading with Zimmerman, "Why are you following me?" And the watch captain's response, "What are you doing around here?" The only evidence of these statements is Rachel Jeantel. And if you watch her testimony, you will understand why the jury didn't believe a word of it. Moments later, Martin screamed, "Get off, get off." Then the single gunshot. Why would Martin scream, get off, when we have an eyewitness on the scene, not a phone witness like Rachel Jeantel lying about her cursive notes? Why would Martin be screaming, get off, when the eyewitness says Martin was on top of George Zimmerman the entire fight until the gunshot was fired? Defense cross-examination was withering, overbearing, and disrespectful of this young black woman with a soft voice relating a traumatic experience. This is a lie. Don West did the cross-examination of Rachel Jeantel, and he treated her gently. Now, was he deliberate? Was he focused? Was he intent on getting at the truth for the jury to see it? Was he vigorously advocating for his client? Yeah, Don West was. But he was not insulting to this witness. You know who was insulting? Sneering, muttering. It was Rachel Jeantel. Watch her testimony. Maybe I'll do a show just on that. That might be fun. Much of the media was equally disrespectful in their coverage of her testimony because her testimony was utterly unworthy of respect. Just watch it. Juror B29, described as Hispanic, later had second thoughts about the verdict. Well, jurors often do when they get back to their communities, and the whole world, who's been propagandized for a year and a half that Zimmerman's a racist murderer, hears that you acquitted a racist murderer. Of course, after the fact, jurors in interviews make up all kinds of reasons why they were misled. It's not their fault. If only they had known. If only they had known the propaganda lies, they might have voted for guilty. What a justice system, huh? She believed Zimmerman's story and said that she'd welcome him as a member to her community if he didn't go too far. I think his heart was in the right place. It just went terribly wrong. Barack Obama's Justice Department declined to pursue civil rights charges. Is that because Barack Obama and Eric Holder, who ran the Justice Department at the pleasure of Barack Obama, both black males, did they decline to pursue civil rights charges because there was evidence of racism on the part of George Zimmerman, but they just didn't want to pursue it? Does anybody believe that for a moment? Or do you believe that the Justice Department didn't pursue civil rights charges because there was no foundation for civil rights charges? As a coda, George Zimmerman announced in 2016 that he was selling the 9mm pistol used to kill Trayvon as an American firearm icon, a piece of American history. Well, it is. And by the way, they had destroyed George Zimmerman's life so greatly that he was unemployable. He was broke. He's starving. He can't live anywhere. And they're going to throw stones at him for selling property to raise money that they won't allow him to raise by simply living a normal life. An immediate legacy of the case was that black parents needed to expand their warnings in the talk with their children to include the risks posed by their white neighbors. Why not their Hispanic neighbors? Maybe don't attack armed people. That would be good advice to give to children of any race. The fear was no longer just the police. Oh, they're already teaching their children to fear the police? White civilians could apparently kill unarmed black males with impunity. You mean defend themselves against life-threatening attack? If there was good reason for George Zimmerman to shoot his gun because he was scared, what black youth is safe if Trayvon was not? Well, how about all the black youth who are not attacking armed people? How about that? Trayvon carried no weapon, committed no crime. He didn't? How about aggravated assault? Pounding someone's head into a sidewalk. Attempting to seize their gun from them. Those are crimes. Was lawfully on the premises. Threatened no one. He threatened no one. Trayvon Martin threatened no one. George Zimmerman punched himself in the face, the prosecution tried to suggest. George Zimmerman caused these injuries to the back of his head himself. That was the narrative the prosecution wanted the jury to swallow. What did he do wrong? What is a mother to advise her son to avoid such a fate? How about not have stolen property in your school locker so you get suspended from school? How about not have drugs in your system? How about not to attack armed people without justification and sustain that attack? How about that? Mothers. One is reminded of W.E.B. Du Bois' question in 1903 to his fellow African Americans. How does it feel to be a problem? Well, if you're attacking people, you're a problem. And they're privileged to defend themselves against your attacks. Then he quotes a prison activist. I don't care about that person. The acquittal set off demonstrations across the nation, precursors to the Black Lives Matter movement. Let's see how that panned out. The phrase was first used regarding the Martin case and the protest after the police killings of Michael Brown, a lawful killing. 12-year-old Tamir Rice in Cleveland, a lawful killing. Tamir Rice reached for an apparently real gun. 200-pound Tamir Rice, who'd been walking around a park pointing an apparently real gun at black people, who called the police and said, send a patrol car. There's someone here pointing a gun at us. The police showed up in their car. Tamir Rice reached for the apparent gun in his waistband and got shot. Eric Gardner in Staten Island. Eric Gardner was killed by his morbidly obese physiology when he violently resisted lawful arrest. And George Floyd in Minneapolis. George Floyd also killed by his physiology. Heart disease, 3 times fatal dose of fentanyl on board, meth on board, violently resisting arrest again. Elijah McClain died when placed in a chokehold by Aurora, Colorado police. That's why Colorado police are now not allowed to use chokeholds under any circumstances because of that event. While paramedics injected him with a fatal dose of ketamine, which was exactly what policy was at the time. Police were responding to a 911 call reporting the unarmed 23-year-old black man was wearing a ski mask as sketchy. Like Martin, his crime was walking home black from a convenience store carrying an iced tea. You think the police initiated an arrest because a black man was walking home from a convenience store carrying an iced tea? You think that's what happened? Trayvon's fate was cruel. Was it cruel? Or did Trayvon create his fate? But not unusual. Who do most black people get murdered by? The police? Or is it 1,000-fold more commonly that they're murdered by young black men in their communities? That's what's not unusual, tragically. American public opinion was sharply divided along racial lines. Yeah, of course, because people had been propagandized by garbage like this, Professor Corbin, over the Zimmerman verdict, consistent with the pronounced divide in public opinion on such defining events as the Rodney King beating by LA police and the acquittal of O.J. Simpson. When you have the racial grievance industrial complex setting fire to the public view of use of force events, that's what happens. You reap what you sow, you hack, Professor Corbin. Now to put Trayvon Martin case in its larger historical context, and he goes on for many pages of another 30 pages of racist drivel. But we will stop. We will stop with Brodin, not Corbin, Brodin, with Professor Brodin's heaping pile of steaming garbage portrayal of the Trayvon Martin case right there. All right, folks, perfect timing. I've got a haircut in 10 minutes. I could use it. Thank you so much for being here. Let me see. I'll do a quick look at questions. It's a 5-minute walk from my office. So let's see. Chuck says Zimmerman messed up. By the way, we only read questions and comments from Law Self-Defense members now on the Law Self-Defense website. So that's the place to go if you'd like your questions to be addressed, folks. If you're not yet a Law Self-Defense member, I don't know why not. 2 weeks, try it out, 99 cents for 2 weeks, unlimited access. And after that, it's only about 30 cents a day. It's less than $10 a month. lawselfdefense.com/trial. We don't read the super chats or rumble rants anymore. The question or comment has to be in the member chat on the live stream on the member dashboard. lawselfdefense.com/trial. And I would also encourage you to consider becoming a platinum member. We only provide our legal consults to platinum members. We don't take outside consults anymore. When we took outside legal consults, they were $10,000, folks. Now we only provide consults to our platinum members. If you're involved in a use of force event, we provide a legal consult in your case, and we do it for free. For free. We'll provide that platinum coverage for you for 5 years. And we'll send you every course and book we have at Law of Self-Defense in every format we have it. That's $3,000 worth of content. We'll give that to you for free. You get all that for 82 cents a day. 82 cents a day. I know you have that rolling around in your car. 82 cents a day, folks. Check that out. And by the way, that platinum coverage covers your spouse too. Both of you. Check it out at lawofselfdefense.com/82 cents. All right, Chuck says Zimmerman put himself in an ambush position, got himself ambushed. Yep, I would agree with that. He made a tactical error, but that's not a crime. Steve says, can a defense attorney get an interlocutory appeal on evidence admission such as photos of the victim? It depends on the jurisdiction. So interlocutory, in other words, can you immediately appeal a judge's evidentiary ruling? You don't have to wait till the end of the trial and a verdict. In Florida, you can. And in this trial, they did many, many times. The defense sought an interlocutory appeal on Judge Deborah Nelson's evidentiary rulings. And every time they did, they won. The defense won. That's a reflection of the bias that Judge Deborah Nelson had in favor of the prosecution. Let's see. Allison says, do judges have any oversight committee that reviews their overtly biased court rulings? Well, you can do this kind of interlocutory appeal we just talked about. That's the only thing that really matters, is if you can do it in the heat of the moment, that day, basically. Chuck says, the guy who wrote this law review article, a rough horse, a cactus. Oh, right. This guy who wrote this law review article deserves a rough horse, a cactus saddle, and a long journey. Yep. Robert says, Andrew, the professor is a piece of S liberal. What do you expect? Well, I guess so. I guess he probably is. All right, folks. Oh my gosh, 2 hours and 20 minutes. I can't believe I've been talking that long. I hope you enjoyed the show. Check us out at lawselfdefense.com/82 cents. 5 years of platinum coverage, my legal consult for free if you're involved in a use of force event, not the normal $10,000 retainer, unlimited access to all our content, a Q&A forum just for platinum members that comes directly to me. You can ask me your questions directly. This covers your spouse too. Every course book we have to offer, all included for 82 cents a day. It's $6,000, folks, of platinum coverage and content, educational content, books, courses, everything for 82 cents a day at lawselfdefense.com/82 cents. What else? So yesterday, I said this at the start of the show, but I know people joined late. Yesterday, I was in a Shrek hearing. I was qualified to be an expert witness in a murder trial taking place here in Colorado. You'll be shocked to hear the judge found me eminently qualified to be an expert witness on use of force law. Surprise, surprise, surprise. And the trial is this week. So it's either Thursday or Friday. It's a murder trial. And I will be testifying as an expert witness at that murder trial. So whatever day the trial is, there will be no show. I'll try to remember to send out an email once I know what the date is, but you should all be prepared for that. The trial is not being streamed. It's not being recorded. Sorry, I wish it was, so you could all watch it. But I will try to get a transcript of my testimony. And if I can, we'll use that transcript for some show content. Maybe I'll read the transcript aloud to kind of replicate the testimonial experience. We'll see what I can do. All right, folks. Thank you. Thank you all for being here. None of this would be possible without your continued ongoing support. I can't tell you how much I appreciate it. And as always, remember, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.